For today's case, we are discussing the recent seizure of the FBI of the safe deposit boxes in Beverly Hills. So as has been covered in the news, the FBI went and seized all the safe deposit boxes. They just took the entire structure out of the wall. They just took the wall, basically, and all the safe deposit boxes from the safe deposit box company. But the warrant said specifically that they weren't allowed to seize the items in the boxes, although they were allowed to do an inventory search. And then they seized the items in the boxes. So one of the questions is, hey, did the FBI lie? Did they exceed their authority? Does it matter? And so the court is addressing that. So let's go ahead and read a little bit more. So this private business is a safe box company. What they do is they run safe deposit boxes, but they're a private company. They're not really a bank. They just do the safe deposit box thing. All right, so they rented to customers anonymously. That was part of their deal. Customers kept all keys to the boxes. The safe deposit box company could only access a box by drilling it open because they didn't have any keys. The facility was also outfitted with significant security, including an iris scan for vault access, hardcore, 24/7 electronic monitoring, 24/7 armed response, and a timed lock on the vault itself. Now, due to the anonymity of we don't care who you are, you can rent a box with us without telling us who you are, the boxes were used regularly by unsavory characters to store criminal proceeds. And this was apparently known and actually desired by the people who run the safe deposit box company. So they knew this, they apparently wanted this, and so they're helping to facilitate potentially illegal conduct. So that's a problem. In fact, the court notes that the company seemingly targeted criminal clientele on its website, noting the less we know about customers, the better, and their service helped customers avoid government agencies such as IRS or attorneys armed with court orders. Yeah, it sounds like you are trying to court a nefarious business. Like, we don't know your names is one thing, but we're going to help you avoid the IRS and court service. It seems like maybe you're doing this with more nefarious intentions. But whatever problems the company had, of course, doesn't necessarily apply to all of its customers. Many of its customers use the service for perfectly legitimate reasons and perfectly legitimate needs. Not all the people who use the company were criminals. Some people just need safe deposit boxes. From 2015 to 2019, the government individually investigated criminals that were regularly using the business to store criminal proceeds. Several different agencies, including the FBI, the DEA, and the United States Postal Inspection Service, which always doesn't get enough love because their jurisdiction is the mail, and the mail goes everywhere. So they're a pretty formidable group, in my view, had different investigations open on individual customers during the time frame. However, after almost 5 years of investigating individual box holders, the agencies concluded they weren't doing anything effective because the problem was actually the business itself. And so the investigation in the business uncovered the fact that the people who ran the business were aware of and indeed actively solicited the use of boxes by criminals. So that is the problem, right? It's like, yeah, you're trying to be an accessory to people. It's not just that you don't know their names, it's that you're courting, you have knowledge of, and you want to be a place for nefarious people. So that was at least what the U.S. government was telling the courts. On March the 9th of 2021, a grand jury returned an indictment against the box company. The indictment charged the box company with conspiracy to money launder, distribute controlled substances, and structure financial transactions. The indictment also included 2 forfeiture allegations, both of which reflected a finding of probable cause that computers, money counters, surveillance equipment, biometric scanners, and the safety deposit boxes themselves were subject to forfeiture as a result of the criminal scheme. The judge who issued the warrants against the company, which identified items to be seized as the safe deposit boxes and keys. The warrant, critically, did not authorize a criminal search or seizure of the contents of the boxes themselves, but did allow the agents to follow their written inventory policies to protect the agencies and contents of the boxes and allow for inspection of the contents of the boxes in an effort to identify owners in order to notify them so they can claim their property. So the judge who signed the search warrant, made a special note of saying, okay, I'm authorizing you to take the boxes themselves, the wall they're in, the biometric scanners, the keys, but I am not authorizing you to seize the contents of the boxes. But of course, what did the government do? Seize the contents of the boxes. So that's the problem. The government executed the search and seizure warrants from March the 22nd to the 26th of 2021. Over the period of time, the FBI inventoried the contents of over 700 boxes. In performing the inventory, agents occasionally found letters taped to the inside, purportedly identifying the owners, but then would continue to do the searches anyway. Once they opened the boxes, agents would examine the box contents, take photographs, and show the contents to a video camera to record inventory. But also, after seizing the boxes and their contents, the government initiated an administrative forfeiture proceeding for any box that contained more than $5,000 worth of value. So even though the search warrant they had specifically said they didn't have permission to seize the contents of the box, there's like, oh, we did an inventory search and now we're going to seize them anyway under civil asset forfeiture for any box that has more than $5,000 worth of value. Now, are we saying it's criminal? No, we're saying it has more than $5,000 of value. And those must be the same thing, right? It's not that anyone could legitimately have more than $5,000 worth of value in a safe deposit box. Why would anyone keep more than $5,000 worth of value in a safe deposit box? Apparently, says the U.S. government, confused and bewildered. Okay. The plaintiffs in the case argue that the U.S. government's actions in the investigation showed a callous disregard to Fourth Amendment rights and are seeking an injunction ordering the government to sequester and return the records generated during the inventory of the search. They argue that the government's search and seizure exceeded the limitations set out in the warrant because they seized items in the boxes even though the warrant said specifically not to, and the government breached its duty of candor by misleading the judge in its warrant application. All right, so let's consider those two factors in play. The first question is whether the government's actions exceeded the bounds of the warrant. The warrant, while authorizing the seizure of the assets of the boxes, did not authorize seizure of the contents of the boxes themselves, but not the contents. Plaintiffs argue the government ignored the warrant strictures against the criminal search and seizures because any purported inventory was a sham, a pretext to rummage through the boxes for evidence. The government counters that the inventory complied with the written policy and was not actually pretextual. Because an inventory search must be non-investigative in nature, the Ninth Circuit has held that an inventory search is invalid if it's a pretext for an investigative search. An inventory is pretextual when the only reason law enforcement performs the inventory is to find evidence of criminality. There is, however, a critical wrinkle in the pretext analysis because the mere presence of a criminal investigatory motive or a dual motive, one of which is valid and one of which is impermissible, does not render the search invalid. Instead, the court asks whether the challenge search or seizure would have occurred in the absence of the impermissible reason. So as long as the government has any legitimate reason, even if they have illegitimate reasons, it doesn't matter, says the court. And so, like, can you conjure any legitimate reason is apparently the right analysis. Whether an inventory search is impermissibly pretextual hinges on one question. Would the challenge search have occurred but for the government's allegedly improper investigative purpose? Here, the answer apparently is yes. The warrant authorized the government to seize the safe deposit boxes themselves and inventory the contents in accordance with standardized policy. The FBI's internal policy requires that when an agent lawfully takes custody of property, he or she must conduct a prompt and thorough search of the contents of property, including searching any locked or unlocked containers. Thus, because the government had lawfully taken custody of the boxes themselves, due to the warrant that searched the seizure of them, the inventory policy mandated they looked at the contents within. The plaintiffs have made much of FBI's policy regarding custody of unknown persons' property, which is alluded to both in the affidavit and warrants. The policy requires agents to inspect the property as necessary to identify the owner, but extend no further than necessary to determine ownership. But plaintiffs ignore crucial language in the warrant and affidavit that, in addition to examining the box contents to identify owners, agents were to conduct an inventory of the boxes, which required them to examine the contents of locked containers. Thus, the fact the agents continued to examine box contents does not indicate an inventory search was pretextual. The plaintiff's other Fourth Amendment argument is that the government misled the judge in its warrant, thus breaching the duty of candor. Specifically, the plaintiff's note in the affidavit states that only the government intended the inventory of box contents, while omitting the fact that investigators were making preparations to forfeit much of the property. Naturally, law enforcement agents may not substitute warrant affidavits that contain materially false omissions. The test for determining whether a false statement or omission is material is whether the affidavit containing the omitted material would have provided a basis of finding probable cause. If probable cause would have remained even if the omitted facts were included, the omission is immaterial. Further, an omission relating to how the search would be conducted, rather than relating to whether the warrant issued, is also immaterial. The plaintiffs do not argue the purported omission, the government had made certain preparation to forfeit the contents themselves, had any effect on the probable cause to search and seize the property, including the boxes. Rather, they base their argument on two Ninth Circuit cases that have identified alternative types of improper affidavits. So this affidavit was not legally misleading because they had probable cause to seize the boxes, and therefore once they seized the boxes, they were going to do an inventory search, and once they saw inside, it's like, well, we're going to seize them. So even though that was their motive the entire time, even if it was, they didn't have to provide it because the ultimate question is if they had probable cause to seize the boxes, which they apparently did, so everything else doesn't matter. Their true motives don't matter. Basically, all that we look to as is typical in these kinds of things is the objective standard of did a reasonable police officer have a legal reason? We don't actually look to their subjective motivations. This is kind of the same thing we do in traffic stops, incidentally, as well. We don't look to whether or not the officer did, in fact, have some sort of improper motivation. We only look to whether or not they could have pulled over the car due to some objective criteria, and we don't worry about the rest. So it's kind of the same standard as to the FBI. We don't care about whether or not they lied on the affidavit or not. Even though lying is bad, we only care about if they had told the truth, and they had enough to seize the boxes, so it doesn't matter that they lied. Okay, well, that's the law, I suppose. Here, the omission by the government that they had forfeiture preparations in place did not create a false impression. The affidavit was rife with details of prior investigation into individual box holders that resulted in forfeiture of those individuals, and noted that the agents executing the warrant would inventory the contents of all individual boxes. Any reasonable magistrate would have inferred the inventory could have led to discovery of criminal proceeds, which would lead to forfeiture. In all, therefore, the plaintiffs have not demonstrated either the omission of the government's forfeiture plan from the affidavit was materially false to probable cause because it would have changed the probable cause analysis, or that the government's conduct in the matter was equal to or greater than violative conduct in other cases. Thus, they find the argument fails. For the foregoing reasons, therefore, the court grants judgment to the United States government that this search was totally fine, and the search and seizure can continue of the boxes, even though they lied, because it didn't matter legally, because they had an objective reason to seize the boxes. So their true motivations is irrelevant because they had both legal and illegal purposes, and all that we care about is legal purposes. So ignore the rest, and everyone can go fight over the civil asset forfeiture. Thus, that brings us to the end of the discussion, for the moment at least, over the boxes that were seized in Beverly Hills. This box company seems to have apparently knowingly facilitated people's crimes. That's what we call accessory after the fact, right? Is it legal to run a business in which you have anonymity? Sure. Is it legal to basically, in fact, openly say, please come help avoid the IRS. We will help you avoid the IRS. We will help you avoid court things. No, not so much. Like you can't really solicit the criminals. So they were engaged in a knowing conspiracy. So we're going to seize all the instrumentalities of their crime, including the iris scanners and the security cameras, and of course the bank, the vaults themselves. We're going to seize the boxes, and then we're going to do an inventory. And then we're going to seize any box that has more than $5,000 worth of value and make the owners prove that it wasn't instrumentalities of crime. So that's what's going on in California. It is a depressing story, but that's the law. And at least for a moment, that brings to the end of discussion of this story.